Okay, I will go ahead and get us started. Good afternoon. Thank you for joining us for the presentation on sponsoring a family member. This webinar is being recorded and the recording link will be emailed to all attendees. This webinar is provided as an educational service by Alcorn Immigration Law. The information discussed by our panel is an overview only and should not be construed as legal advice or advice to take any specific action. Please be sure to consult a knowledgeable professional with assistance with your particular legal issue. And please submit any questions you may have to the Q&A function. The questions do get shared publicly, so please do not share any sensitive or personal information. There is an option to submit your questions anonymously. We will try to get as many questions as time permits. And it is my pleasure to introduce to you our partner attorney, Anita Kamrikian, and associate attorney, Corey Faruqi.
Thank you so much, Edith. Good afternoon, everyone, and thank you for joining us this afternoon. Happy almost Friday. Super stoked to be joined with my associate attorney, Corey Faruqi. Thanks for joining me, Corey.
Thanks for having me.
All right, so we can go ahead and dive in. As Edith mentioned, our discussion today is about sponsoring a family member, which is a true honor, a true privilege that I could say as an immigrant myself is what a lot of people strive for. I want to be able to become a green card holder, a US citizen, so that I can sponsor my loved ones, my siblings, my parents, my children, my spouse, and everybody of that nature. And we'll slowly go through and walk through what your options are as a US citizen being able to petition for family members, or if you're only a green card holder so far, and what options you have to sponsor a family member as well. So we can go ahead and just dive right on in. Here at Alcorn Immigration Law, what we do, we strive to overcome borders, expand opportunity, and connect the world by practicing compassionate, cutting edge, and rigorous immigration law in the service of the betterment of humanity. And we pride ourselves on having a really high and great success rate. I think that we're at about a 95% success rate overall for all of our cases, which is exciting and is kind of a big deal, especially considering what the last 4 years of immigration looked like. What we do is we help keep the American dream alive. We help people realize their American dream still, if they want to. This is me. I'm Anita, a proud alumni of Santa Clara Law and UCLA. I went there as a little undergrad. Go Bruins. I have experience. What holds my heart is family-based immigration. As the partner at Alcorn Immigration Law, I practice both family-based immigration as well as employment-based, but family-based is what I love the most and hold an expertise in. And I also have experience practicing family law, so divorce, custody, all of that area of law, which gives me a leg up with my family-based immigration practice. I'm an immigrant myself. I am a proud American, became a citizen through my dad when he became a citizen, and we got our green cards through the F4 visa category, which we'll be talking about, the sibling category. I'm Armenian, 100% Armenian, super proud of that. And I was born in Iraq. I was born in Baghdad, moved to the States again when I was 4 years old, and love that. This is mine and my adorable sister's green cards. This is me down here. Our green cards were actually pink, which is pretty funny. Although they're green cards, they're pink cards. We were still called resident aliens. Resident aliens is no longer a title that our current president allows or is saying is permissible anymore. Everybody is, if you're not a green card holder, you're a non-immigrant. You're no more alien, no more terrestrial terms for people who don't have their green cards. This is my incredible associate attorney, Corey. Corey, why don't you go ahead and introduce yourself?
Yeah, so I'm also a proud alumni of Santa Clara Law. For undergrad, I did go to UC Santa Cruz, majored in psychology, which kind of guided me to immigration in some interesting way. I did end up working at a nonprofit doing humanitarian immigration law for a few years, and I really enjoyed that. I got to tie all my interests in together. Now at Alcorn, I am specializing in family immigration, which I love. It's great. I am proud child of an immigrant father, and I have a very diverse family. My husband's family is a family of immigrants. I have uncles and aunts and all sorts of family who originated from different parts of the world. And so immigration has been a very, very good fit for me.
Yeah, and I think that's what kind of supports us. I think, yes, our next slide is all of our team, our wonderful team. We are growing, we have been growing, which is super exciting. But everybody you see here is either a child of an immigrant, married to an immigrant themselves, or somehow connected. It's in all of our DNAs some way or somehow, and that's what helps us be so compassionate and thoughtful and mindful of the work that we're doing. Because we get it, we understand, we feel you, we hear you when you're stressed out and you don't really know what's going on with your immigration journey, and we're here to hold your hand, to support you throughout the entirety of the process. Wrong way. This is our wonderful network. We are supported by individuals in these networks. We support them, individuals in these networks as well. So we're proud of the network that we hold. Now let's just kind of dive right in with a quick little immigration overview. Typical pathway. There's two main pathways that individuals can go down with their American dream, their U.S. immigration journey. An individual can either enter the United States with a visa, a temporary visa, a non-immigrant visa, and then change their status while they're in the United States from visa holder to green card holder, and then become a U.S. citizen. Alternatively, which happens a lot in the family-based categories, is somebody can actually just enter the United States with just a green card, an immigrant visa. So a lot of parents, maybe their child will petition for them, and they've never been to the US before, or maybe a spouse has never been to the US before. They don't have a visitor's visa. So somebody in the United States will petition for them in order to get their green card. They get their green card, and then the first time that they're stepping foot into the United States is as a green card holder. That's how I entered the United States, and it's pretty neat to go down that pathway. So two ways that you can enter the United States. So diving right into the May Visa Bulletin. The Visa Bulletin is kind of an archaic portion of immigration law that dictates how many people can enter the United States per country, per visa category. I say it's archaic because it was kind of it was decided, okay, if you're moving on to the next slide, if you're from individuals from China, India, Mexico, and the Philippines, these people were going to limit how many green cards or visas, immigrant visas, are going to be available to these individuals. So with the family sponsored preference categories, it dictates how quickly somebody will be able to obtain their green card and enter the United States, or if they're in the United States already, how quickly they'll be able to file for an adjustment of status to get their green card. These are the main family-sponsored visa category. One that is not mentioned here is the immediate relative visa category, and it's intentionally not here because immediate relatives of US citizens are not subject to the Visa Bulletin. An immediate relative of a US citizen is either a spouse, a parent, or sometimes a child, depending on their age. So with that, they're not subject to this Visa Bulletin, which dictates how quickly they can enter the United States. One category that comes up a lot, that a lot of people will fall under, is the F2A visa category. And this is for spouses, particularly spouses of permanent residents, and even children of permanent residents, but primarily it's spouses, so green card holders. So if I'm a green card holder and I want to petition for my spouse to get their green card, they would be subject to the Visa Bulletin. And so here I would say, okay, going down to the visa bulletin, I see the letter C next to that. Right now, that means that individuals under the F2A category are not, there's no wait in order for them to obtain their green card. Historically, the F2A visa category was backlogged about 2.5 years. And for the last almost 2 years, it'll be 2 years in August, there has been no backlog in the F2A category, which has been incredible. So just pretty interesting. Other common visa categories that we'll look at today throughout is the F1 visa category, which is for children of U.S. Citizens, unmarried children of U.S. citizens, and we'll go through what that means. But essentially, this is if I'm over the age of 21 and I'm not married, I would fall under the F1 category. But if I am married and I'm over the age of 21, I would actually fall under the F3 category. So a little bit confusing. Nevertheless, it's all laid out on the visa bulletin. But it's down here that it starts to get a little bit frustrating, the visa bulletin, because it moves rather slowly. So looking down here at the F4 visa category specifically, and we'll talk more in depth, but you can see that individuals who filed their green cards in 2006 from any country, for example, if I'm going to petition for my sister who lives in Armenia, if I filed my green card application for my sister in Armenia in 2006, that's what USCIS, or what the Department of State rather, is adjudicating green cards right now for, or issuing green cards for. So that means it's about a, I should have done the math, 21 minus 6. We are at a 15-year backlog. So if I were to want to petition for a sibling now, it's going to take 15 years for my sibling in Armenia. But let's say I have a sibling in China, still backlogged 15 years. A sibling in India, goodness, we're going now, it looks like it's 16 years. I have a sibling in Mexico, holy cow, we're backlogged to 20 something years. It's going to take for my sibling in Mexico in order for them to get their green card. So this is the visa bulletin. It's a little bit frustrating, archaic. A part of what the Biden administration has said is that they want to take a look at this, which we'll talk about it towards the end of today's presentation. But some interesting stuff going on. The visa bulletin has 2 different charts now. I think this started, they published the 2 different charts. It's been several years now that they've had these 2 separate charts. Chart A is what USCIS, or what the Department of State, they're handing out green cards for these people right now. Chart B is individuals who filed their green cards. Again, let's say we're looking at the F4 visa category. Individuals or family members who filed their green cards, that filed their petitions in 2007, that's when they can start submitting additional information and documents to either USCIS or the National Visa Center, depending on what type of case that we're moving forward with. But that's when they can start essentially giving the documents over to the government, because it's going to take them a while to review them. And by the time they get to reviewing them, by then the visa bulletin will become current and they'll be able to actually get that green card. So Bulletin A, Bulletin B, interesting. I should stop saying that, but it's interesting stuff. There's 2 different ways that an individual can get their green card. There's the adjustment of status pathway versus the consular processing pathway. Corey, do you want to walk us through the different pathways?
Sure. So starting with the adjustment of status. So who can adjust their status? So this can be an individual who most recently entered with a valid visa or through the visa waiver program. Most of these applicants have to be in lawful status when they're applying, even if their status later expires. How to get a green card through the adjustment of status. So we always recommend first talking to an attorney about your eligibility. And then with the adjustment of status, typically you are filing an I-130. Well, not typically, I guess it depends, right? We're going to go into detail about that. But generally there's an I-130 petition that's going to be filed. In some situations, it is filed concurrently if there is a visa available to you. I think the categories that we're talking about today most likely the first step is going to be the I-130 petition, and then waiting for your turn for that green card based on that visa bulletin that Anita was just discussing. Once the I-130 is approved, then again, waiting for that visa bulletin and then filing the green card application. And then if you are in the US, you will be waiting for an interview. So that will come next after filing that application. And once you receive the once you're scheduled for an interview and you attend your interview, your green card is approved, and then you will be allowed to legally work and travel in and out of the United States.
As a green card holder, yeah, absolutely.
As a green card holder, yes.
So one question I guess that we should clarify for our listeners today, Corey, is how does somebody get that priority date? So let me go back a couple of slides. How does somebody know when to start looking at these dates?
Yeah, that's a good question. So when your I-130 is filed, the date that USCIS receives that I-130, that will be your priority date. So they will give you that priority date, and then you're waiting for that priority date to appear on the visa bulletin. So that is the priority date that we're referencing.
Got it. Super helpful. All right. And then consular processing. Consular processing, this is that second track, that second pathway that we were discussing earlier. Why don't you go ahead and walk through?
So applicants who can typically consular process are applicants who are living outside the United States. How do you get the green card through consular processing? So that I-130 petition again is filed with USCIS, and then you are waiting for it to be approved. Once it's approved, you're still again waiting for that priority date to become current on the visa bulletin. Once it does become current, you can move forward with the rest of the green card application process, which includes submitting documentation and completing something called a DS-260. And then eventually attending an in-person interview at a consulate abroad. Once you attend that interview and it is approved, you will be issued an immigrant visa in your passport that allows you to enter the United States as a green card holder. And again, with that the green card in hand, you can legally work in the US and travel in and out of the US as well.
Awesome, thank you. All right, we received a question, and let me answer it now just so that we can. One of our viewers asked, which of the categories applies to parents of US citizens, F1, F2, F3, or F4? Parents of a US citizen, a parent of a US citizen is actually an immediate relative. And as an immediate relative, they're not subject to the visa bulletin, meaning that if they're going through the consular processing pathway or the adjustment of status pathway, whichever one it is, if they're in the US or not in the US, a visa is immediately available to them. And assuming that everything goes smoothly, a parent of a US citizen can expect, just in terms of timeline, can expect to get their green card in like 1 to 2 years maybe after they file the green card application. Again, pre-COVID, so this is not like no time buffing or adding on for COVID. All right, so let's go ahead and move on. Speaking of immigration during COVID, has it been a fun year as an immigration attorney? A slogan that I live by is, there has never been a dull moment. It's been interesting, but immigration has lived on. We have experienced some severe backlogs with immigration, which we'll talk about in a second. But life keeps chugging along despite a global pandemic. So what has immigration looked like during COVID? There's been, again, like I just mentioned, some pretty bad delays with biometrics being scheduled, with cases being scheduled for interview, even things as simple as receipt notices being sent on cases that have been mailed. USCIS is doing their best to abide by COVID restrictions, by guidelines, to make sure that things are operating in consideration of the pandemic, which has resulted in these delays, these backlogs that are being created. Telephonic appearances at local USCIS interviews. So USCIS is encouraging attorneys specifically to appear out telephonically at USCIS interviews and has started to permit that amidst COVID. The applicants, so our clients, still do have to appear in person, but attorneys are being encouraged to attend the interviews telephonically, just to decrease the amount of bodies, the amount of people in the local offices, but also just keeping in consideration that while the officer and the client can have a barrier that separates them, a plexiglass barrier that separates them during these interviews, the attorney and client are going to be sitting side by side. So what their solution is, okay, well, what if we call in these attorneys, and the attorneys can listen in and chime in and support their clients that way. We've been doing that for the last year now, over the last year now, and it's worked. So we're very, very grateful for that. Proclamation functioning as a visa ban was lifted, which is super exciting. So there was a point in time where there were a lot of various proclamations that said people from this country can't enter the United States. People trying to obtain an H-1B visa, an L visa, no more of that. Those types of visas being scheduled for interview and approved at the consulates. No more green cards at the consulates. So a lot of those proclamations were lifted, but the COVID travel restrictions are still in place by presidential proclamation. So can you chime in, Corey, a little bit about what that looks like?
So like Anita was saying, the proclamations that were essentially functioning as visa bans have all been revoked at this time, but all of those COVID travel restrictions, so the proclamations that are requiring that you quarantine for 14 days before entering the US if you're coming from the Shenzhen area, I might have butchered that a little bit, China or Brazil. There's a host of countries that have been listed. So those restrictions are all still in place. So even if you do have a valid visa to enter the US, you still have to do that 14-day quarantine in a different country if you're coming from that country before entering the US.
Right, and we've worked with a handful of clients to kind of help them work around that day. A lot of people have taken some 14-day trips to Mexico, a nice little vacation for them in order to be able to enter the United States. So it's been, creativity is required. And then USCIS has been, I'm sorry, not USCIS, well, USCIS too. There's been expedited appointments that are available at the local USCIS offices, at the worldwide consulates as well. They're difficult to get though, if I'm going to be very frank and honest with you all this afternoon. Basically, from what we understand is unless somebody is dead or dying or is going to be curing COVID, they're not going to be entering the United States. Yes, there's other national interest exceptions and exemptions that these expedited appointments can be scheduled for, but they're difficult. And what we like to do is we'll still support our clients with it, and we can support all of you all with them as well. But we like to set our expectations of we're going to try, but don't hold your breath, basically.
And then just to expand a little bit there, Anita, I think also sometimes like these expedited appointments are particularly hard to get in family-based cases just because they're not being prioritized when it comes to expedited appointments, because like you said, if you aren't carrying COVID or there isn't a very serious situation, then you just have to wait your turn until the consulate can schedule you and proceed with your process.
Perfect. Yep. Thank you for chiming that in. All right, let's keep going. New entry requirements, COVID tests. So this is a new, I think this kicked in January, mid-January, and you are required to present a negative COVID test that was taken no more than 3 days before you traveled by air into the United States in order to gain access into the US. You either have to show your negative result to the airlines before you come in, or if you do test positive, you're going to have to show documentation as to how you're not contagious, how it's not going to be a problem that you have this positive test. and it's basically okay for you to travel. I mean, I'm not gonna say I'm no doctor to sit here and tell you about COVID, but I think what this is particularly going towards is there's people who did at one point have COVID, and then after you have COVID, sometimes there's this potential or possibility that you continue to test positive. So I think that's what they're trying to work around and work towards, which is fantastic, if you ask me. Okay, so jumping in, how to sponsor your children. As a green card holder or as a US citizen, what do you have to do in order to sponsor your children? So who is eligible to sponsor their children? US citizens or green card holders who are over the age of 21 are able to petition for their children to enter the United States, so long as they can show that they meet a minimum financial amount as a sole petitioner, in order to essentially financially support the person that they're bringing into the United States. So that is across the board. All types of family-based petitions require an affidavit of support. They require you to prove that if I, the petitioner, am asking my family member to enter the United States, if that family member that enters the United States becomes a public charge, gets food stamps, welfare, any type of money from the federal government, if my family member that I petitioned does that, I personally will pay back the government, and I can show you that I can pay back the government for whatever my family member took, because I make above the poverty guideline. And I have this household income to support my family. If I don't work, for example, or for whatever reason I'm unable to present that, I can get a joint sponsor. So maybe Corey will be the joint sponsor for me to petition for my family member. If my family member becomes a public charge and I can't pay back the federal government, then Corey at that point will be on the line to pay back the federal government what my family member took. And then, so what children qualify? This is where we'll break down the different visa categories. So the F1 visa bulletin category, again, is for unmarried sons and daughters of US citizens. This says how many visas are available per fiscal year for unmarried sons and daughters of US citizens. Again, an unmarried son or daughter is somebody that's over the age of 21. So they're not in the government's eyes or in the immigration's eyes. A son and daughter is no longer a child, but because they're unmarried, they're in a separate category. And then now jumping down to the F3 visa category, if this son or daughter is married, it's a different visa category. So again, that they too have $34,400 visas available to them on an annual basis. And then there's the F2 visa categories. So here we have, those were for US citizens. So if I'm a lawful permanent resident and I'm a green card holder and I want to petition for my child, now again, a child is somebody who's under the age of 21 and unmarried. They'd fall under the F2A visa category. And if I have a son or daughter, again, over the age of 21, who's unmarried, they'd fall under the F2B visa category. And then just taking a quick peek, I thought I had the visa bulletins here. But going back again, the categories, the backlogs for them, all of these have backlogs of some sort, except for the F2A visa category, which is the unique category that has historically had about a 2-year backlog, but for the last 2 years, they have not had a backlog. What about non-biological children? Do they qualify? You bet, they sure do. Gets a little bit complicated. The ages continue to get a little bit wonky. There's random ages and numbers that are thrown out there. But a stepchild does qualify as a child, so long as the marriage to the spouse was entered into before that your stepchild turned 18 years old. If that's the case, then yes, you can petition for your stepchild. If that's not the case, unfortunately not. What about an adopted child? Do they qualify? Yes, as long as the adopted child was adopted before the age of 16. So again, kind of some random ages that are thrown out there, but they don't necessarily have to be your biological children. How do you sponsor a child? Corey, do you want to go through these?
Yeah, so there's two different scenarios for sponsoring a child that we have here. So scenario one is if a child is already in the US in non-immigrant status, the US citizen or LPR can file a petition for the child, and then they can apply for adjustment of status. The second scenario is if a child is outside the US, so US citizen or LPR, again, is going to file a petition, and then once the visa bulletin becomes current, they can go through with the consular processing and complete the green card application there.
Perfect. And then what kind of non-immigrant visa status? Can you give us some examples of what are some non-immigrant visa statuses potentially that a child could be in the US with?
It could be, I mean, there's a variety of non-immigrant statuses. So it could be, they could be a dependent on their parents' H visa or a visitor visa. They could even enter possibly on a visitor visa.
Not ideal, but yeah,
not
they
ideal.
definitely could. They could be students, things of that nature. Essentially, they need some sort of visa status in the United States in order for them to be able to maintain that underlying status while a green card application for them is pending.
And then I just want to make clear just to our audience that when we're saying child, we mean child in every category. But then when we're talking about immigration, just keep in mind that child means under 21 and unmarried. But we're using it a little bit broader right now just to not cause any confusion of just including that unmarried son and daughter and child as well.
Awesome. All right, sponsoring your sibling. The sibling category. A category that the last 4 years has been almost on the chopping block a lot. The Trump administration had always said that they want to get rid of the F4 sibling category. I don't know why. It's a category that is near and dear to my heart. So who is eligible to sponsor their siblings? Only US citizens can sponsor a sibling. So if you're a green card holder, hang tight, become a citizen, then you can sponsor your siblings. You have to be over the age of 21. And again, that financial obligation is required of you. It's not required of you right then and there when you're initially filing that I-130 petition, but it will be required for you 15 to 20 plus years from now when the family member is actually your sibling and their family could possibly be entering the United States. So it's later on down the road. How do you sponsor your sibling? It starts off with that I-130 petition for your sibling. You have to establish that you have a qualifying sibling relationship. So you have to show that you share at least one parent with that sibling in order to be able to petition for them. You file that I-130 petition, and then you kind of just have to forget about it. The processing times for these I-130 petitions are, I want to say they're like over 5 years. I don't remember it off of the top of my head because what we do too is we file and we kind of forget about it. But the way that works is, again, it takes super long to even be approved. Once approved, then it's the waiting game for the visa bulletin to become current. Once the visa bulletin becomes current, so again, think family members, siblings who in 2006 filed their I-130 petition for their sibling, that's when they enter stage 2 of the process, and they can either go down the adjustment of status pathway or consular processing. Realistically speaking, these individuals are going to be going down the consular processing pathway because they unless they've been maintaining a separate underlying status for the past 15, 20 years, realistically speaking, they're not in the United States. So then you go through just the process of getting your green card once the visa bulletin is U.S. citizens sponsoring your parent. One of our viewers asked about this one earlier, so go ahead and ask some more questions if you have any about that. Any more questions about that? And let's see, who's eligible to sponsor their parents? U.S. citizens. Got to be a U.S. citizen in order to sponsor your parent. You can't be a green card holder. Unfortunately, another one of those categories that you have to be a U.S. citizen. You have to be 21 years of age, and you have to, again, be able to say that you can financially support your parent. With this one, oftentimes it depends on whether or not you're moving forward with the I-130 process, or if you're moving, it depends on if you're moving forward with an adjustment of status application or if you're moving with consular processing. If you're doing an adjustment of status, since a parent is an immediate relative not subject to the visa bulletin, you can file the I-130 petition and the I-485 green card application concurrently together if your parent is in the United States and your parent entered the United States at some point in time legally and has never left the United States before. So let me take a second to sit on that for a second. So hypothetically speaking, I don't remember if I have any hypotheticals in the next slides, but hypothetically speaking, if my family entered the United States 20 years ago as visitors, actually, let's say my parents entered the United States 25 years ago as visitors, and then they had me, and I was born in the United States, and I'm 21 years of age now. Because I'm 21 years old, I am a US citizen, and my parents entered the United States legally 25 years ago and have not left the United States since. I am then the beautiful golden ticket to my parents, and I can help my parents get their green cards, despite the fact that they entered the United States 25 years ago and have been living undocumented since then. So if you find yourself in that pathway, in that category, you can be the golden ticket to your parents, and it's super exciting. I love helping families like that. So that's certainly a pathway and option for you. Another one that happens a lot is I get a call and I'm speaking to them and they say, hey, Anita, my mom and my dad are in the United States. Let's say they're from India. My mom and dad came to the US from India 3 months ago, and they entered the US as visitors. And now I don't really want them to go back home. I want them to stay with me. I want to petition for them to get their green cards. Can I do that? And I say, sure. What was your mom and dad's intent when they first entered the United States? Did they plan on going home back to India? Or did they mean to enter the United States as a visitor and file a green card application? If you entered the United States with the intent in mind that I'm going to enter the US as a visitor and file a green card application, I will say, in order for me to protect your mom and dad, tell them to go back to India and let's file a green card application for them through the consular processing route. It is robust, it'll be ironclad, it'll be a stronger application for them. If the intent of your parents was to misrepresent their intentions at the border to gain access into the US to file a green card, it's not worth it for them to put themselves at risk to get their green card while in the US through the adjustment of status process. Do consular processing. Consular processing is just as fine. It's beautiful. It's lovely. With that, you do, again, it's the same. You file that I-130 petition. Once that I-130 petition is approved, you move on to phase 2 of the 3-step process, as I like to call it. You go to step 2, provide information and documents to an entity in the US called the National Visa Center that collects information and documents for the consulates around the world. Once the National Visa Center has everything that they need and the consulate has available visa appointment for you, then the National Visa Center will schedule an appointment at the consulate for your parents to attend the visa interview at the consulate. Assuming everything at that consular interview goes well, your parents get their passport back with an immigrant visa stamped in their passport, and they enter the United States as lawful permanent residents. So that's how you do it. I think I had a question trickling in about what is the typical processing time for I-130s for US citizens? The I-130s on average take about 6 to 8 months. The entire process from start to finish, so filing that I-130 petition until having them enter the United States with their green cards, pre-COVID was about 15 to 18 months. During COVID, I honestly don't even know because the consulates are closed for the most part. And there's just so many backlogs that I can't even approximate what the processing times are right now. But let's just say pre-COVID, it was about 15 to 18 months. I would add on an additional year now just because of the backlogs and how long everything is taking. But that is just a complete guess. So I hope that answers your question for you. Typical processing time for I-130s and just the green card process for consular processing, about 15 to 18 months. Let's go on. Actually, before we move on, another one of the questions that somebody asked is, can you petition for a step parent or an adopted parent? Yes, you can. That's a great question. It does not have to be your biological, your parent that birthed you. It just has to be a step parent. A step parent can work. You can petition for a step parent as well, which is super cool. And same with adopted parents as well. All right. Beyond green cards, U.S. citizenship. So after an individual has had their green card for 5 years, sometimes 3 years, maybe if you're married to a United States citizen, then so requirements for U.S. citizenship is that if you've living in the United States as a lawful permanent resident, you're eligible for U.S. citizenship. With U.S. citizenship, there's a couple of different things that they're considering. Have you maintained your physical presence in the United States? Do you have any trips outside of the United States for 6 months or longer? Are you a person of good moral character? Do you file your taxes? Are you a criminal? Things of that nature. The USCIS officer reviewing your U.S. citizenship application will interview you. They will test you on your English reading. They will test you on your English writing. They will have a civics test administered to you. So it's a verbal civics test that each individual gets. It's an individual test where you're expected to study 100 questions. Of those 100 questions, the officer will ask you 10 of them. Of those 10 questions, as soon as you get the first 6 correct, then you have passed the civics test. And then you can move on to the rest of your application. So USCIS just expects you to have a D average in order to say that you have passed your civics test portion of the application. After your interview, assuming it's a successful interview, you will ask to give the oath of allegiance to the United States, where basically you raise your right hand, you swear that you're going to preserve, protect the United States, blah, blah, blah. And then you're officially a U.S. citizen. They will take your green card from you and they will give you a naturalization certificate. And you're officially a freshly minted U.S. citizen. And with that, you can go and get your U.S. passport. The U.S. allows for dual citizenship. So if the other country that you are a citizen of, if they allow dual citizenship, then you can certainly become a dual citizen of the United States. Some countries that I can tell you off of the top of my head that do not allow for dual citizenship or who give you a hard time with U.S. citizenship is Japan, Germany, India, I want to say Brazil. I may be wrong. Any other countries that you know off of the top of your head, Corey?
I want to say Austria as well, but
yes.
Mm-hmm.
But yeah, so dual citizenship, it's a thing. It's possible with US. So, yep. All right. Corey, tell us, what does immigration look like under the Biden administration?
Yeah, so can you go ahead and go to the next slide?
All right, thank you.
Thank you. So Biden's administration has released this 6-pillared immigration plan. It includes undoing Trump's changes, modernizing the immigration system, welcoming immigrants, supporting asylum seekers and refugees, supporting people to have safety in Central and Latin America, and implementing effective border screening. So these things some of these things that they've already started rolling out new procedures and new things. What has already been done, Anita, if you can go to the next slide, please. Since January 20th, so the Biden administration has ended the Muslim ban. They have made deportation changes to protect children. They've pulled funds from the border wall. They're strengthening programs for refugees and asylum. They've replaced Buy American, Hire American. They've also reinforced the DACA program and have given their full support to that continuing as well. In addition to these things, there have been several proposals for new laws that have been put into place or they've started to get the proposals rolling to hopefully someday become law. None of these things that we're going to discuss are law just yet. So I think that's really important to say and acknowledge, but they are things that are being discussed by Congress. So the first one here is the U.S. Citizenship Act of 2021. Just moving on here. So some of the things to highlight with this act or with this bill that is being introduced is that it would, and related to employment immigration, it would allow for more working visas, clear green card backlogs, reduce lengthy priority date wait times, eliminate per country caps. It would provide a new green card pathway for advanced STEM grads from U.S. universities, make H-4 EADs permanent, prevent children from aging out, and create new regional economic development green cards. So those are just some of the highlights in relation to employment immigration. When it comes to family immigration, what it would do is allow beneficiaries with an approved I-130 visa petition to enter the US while they're waiting for their priority dates to become current. So that would be really exciting as we looked at those really, really long wait times on the visa bulletin there for some of those categories. It would also eliminate the 3 and 10-year bars. So we didn't really talk about this, but there are some consequences if you are in the US unlawfully and you do depart the United States. There's a lot of nuances to that, but it could create a bar and not allow you to enter the country again for 3 or 10 years. It would also make it easier for spouses and children to join their families already in the country, speed up processing by increasing the number of green cards and recapturing unused green cards, also increase the number of green cards in the diversity visa lottery. In addition, to stop using the word alien and change it to non-citizen. So they've already started getting the ball rolling on that last one. For sure, it just hasn't been official. It's not official in the law, but it's already starting. That change we're already starting to see. So that's been really great. The same Citizenship Act would also provide a path to citizenship. So it would have a 2-tier legalization program. It would automatically make farm workers, TPS holders, undocumented immigrants who came to the US as children eligible for green cards. After 3 years, those same people could apply to become US citizens. It would provide temporary deportation relief. And then just like any other application, it would require background and national security checks. It would require that the individual pay their taxes, pay application fees, but it does have this pathway to citizenship in there as well. In addition to this act, there have been 2 other acts that have been introduced. So they are specifically called DREAM Acts. There's 2 versions of the DREAM Acts that are currently before Congress. There is the DREAM Act of 2021, which was introduced by the Senate. And then there's the DREAM and Promise Act of 2021 that was introduced by the House of Representatives. So again, these are not laws, they've just been introduced. Both bills, though, would provide a path to citizenship for Dreamers, but the House of Representatives bill would also provide a path to citizenship to people who are TPS holders and who have deferred enforced departure. So the DREAM Act has a 3-step pathway to citizenship. So the first one is conditional permanent residence, then permanent residence, and then ultimately naturalization. Each of those have their own requirements that we're not going to go into too much detail about, but they do have requirements of you being of good moral character and being in the United States for a certain amount of time and things of that sort. So the typical requirements that you see in a lot of application types. In addition to that, though, we can discuss a little bit some of the differences. So just to highlight some of the differences in these two bills is, I think the ones that stand out to me the most is just the period of the conditional permanent residence requirement. So for the Senate one, you do have to be a conditional permanent resident for 8 years, whereas for the House of Representatives, you have to be a conditional permanent resident for 10 years. They both have some criminal convictions that disqualify you. So there's just some minor differences there. And then the exceptions that they both have, which I think also stands out to me, is that crimes related to lack of immigration status, those don't make you ineligible. And then the House of Representatives bill also includes exceptions for traffic offenses, certain marijuana related crimes, which it might be interesting for a lot of people since there has been a lot of conversations about the marijuana being allowed in certain states, but then, it's still a crime under federal law. So just some things to just point out about those bills right there.
And again, these are not yet law. We're keeping our fingers crossed that these will be enacted, and we'll ultimately see what happens, but not law just yet. So we'll go ahead and start answering some of your guys' questions. We've already answered a couple of them, but we'll go through. If you have any questions for either Corey or I about what we discussed today, feel free to put them in the Q&A portion, and we'll go ahead and answer them. But I'll start off now. With our last 5 minutes left of today's webinar. Which of the two options is better in terms of likelihood of approval versus time to getting in? What are the pros and cons? Asking for my mother, who comes in regularly to visit as a tourist and is Indian born. So assuming whoever asked this question, I'm assuming that you're a US citizen, because again, you cannot petition for a parent unless you are a US citizen already and over the age of 21, of course. But with that, it really all depends on, it depends on the facts of what's going on. If your mom comes in regularly to visit as a tourist, I would realistically, unless your mom's in the United States right this second as I speak during this webinar, I would go ahead and encourage you to move forward with a consular processing application. Like I said, it is the straighter, the stronger pathway that leaves room for less interpretation by USCIS that misrepresentation was committed at time of entry as a tourist. Because again, if mom is entering the United States as a B1, B2 visa holder tourist, mom is saying that at the end of my 6-month stay, I'm going to go back to my home country. And if she enters the United States as a tourist, files a green card application, the USCIS officer reviewing your application or mom's application will say, wait a minute, mom said that she was going to go back to her home country at the end of her 6-month stay. Why did she file a green card application the next day? What happened? What were the change of circumstances for us to be able to approve this and assume that there was no misrepresentation that was committed at that time? So to answer your question, if it was my mom that I was filing for, I would just do a consular processing application and still have her come in and out as a tourist while the green card application is pending. So if you're pursuing a consular processing pathway, mom can still enter the United States as a tourist while the process is ongoing. It won't prohibit her from doing that. If you have more questions about this specifically, feel free to reach out to me, and I'd be happy to have a one-on-one consultation with you to determine what your options are, what is in your family's best interest. Next question, with adjustment of status, if parents are here in the US, do you need to leave if their 6-month time is over? It all depends. With the law, the answer is always it depends. But ultimately, and I can overall tell you that once you enter the United States and you're in the US and you have filed an I-485 green card application, Once you file that application, you enter a period of authorized stay. It's authorized stay given to you by the Attorney General, whatever that means. But let me tell you what that means. That means that when you have filed the green card application, you're permitted to stay in the United States until that green card application is adjudicated, until they approve the case, they deny the case, they act on that case. So you are neither legal nor undocumented. So a little bit complicated, but to very plainly, yes or no, answer your question, do they need to leave if their 6-month time is over? The answer is no. Do they need to, if they're here as a tourist, do they need to file a second B1, B2 visa extension in order for them to have an additional 6 months? The answer to that also is no, because again, we have to keep in mind the tourist visa has the single intent that when the time expires, they're going to go back to their home country. If you're going through the green card application process, that is a full permanent residence application. So we want it to be very clear that the intentions they're complete opposite intentions, and we want to make it whatever it is that their family is intending to do clear. Somebody wrote, very glad to hear about the stopping the usage of the word alien. About time. I know, right? 4-year-old me was very offended when I was considered an alien. People made fun of me. I didn't like it. But again, no more terrestrial terms. All right, next question. If my parent has completed the 10-year bar outside of the United States in their home country, can I begin the process of their green card now? The answer is yes, you can start the process of their green card now. Your parent will need an additional waiver and permission to still enter the United States despite the end of that 10-year bar. So if you have any questions about that, feel free to reach out to us and we can support you and guide you throughout that process. But the answer is yes. Are people born in Hong Kong follow the same priority as China now? From my understanding, and this changes actually interestingly quite often, Hong Kong is considered a part of mainland China. So they are subject to the China visa bulletin category and criteria. I believe I have answered all of the questions. Are there any new ones? That is all today. Thank you all so much for attending our webinar this afternoon. Let us know what we can do to support you. Please consider us all resources. You can follow us on LinkedIn, Twitter, Instagram, Facebook. We're all over social media. And subscribe to our podcast. It's called Immigration Law for Tech Startups. There's a new episode every Tuesday. Mostly it's hosted by Sophie, but Corey and I appear on it often, and we discuss some family-related topics as well. We've done DACA, we've done the DREAM Act, the just changes with the Biden administration, and have a listen. It's a fun podcast. Call me biased, but I think it's a fun podcast. Thank you all so much for attending today. If you have any questions, again, please feel free to reach out to us and let us know what we can do to support you. Have a good afternoon. Take care.